welcome to MindSafe 360's podcast, The Future of Workplace Mental Health. And today we're going to be talking about Kozarov versus Victoria. And I have Dom Fleeton, who is a partner from K&L Gates, joining me. And we're going to have a look at this case, unpack it a little bit, and just to see what the key findings are, that what employers can actually take away from it. So, Dom, welcome.
Thanks, Emma. Thanks for having me, and hi to everyone listening. So just a bit of scene setting in terms of this case, or what occurred before the case got into court. So Miss Kozarov was a solicitor employed here in Victoria by the Office of Public Prosecutions. And as part of her work, she was required to work with victims of child sexual offences. And as you'd expect, in the course of that work was very frequently exposed to very disturbing material, including child pornography. And this was, the core part of her role. And when she started with the OPP, which was back in 2008, the office did have certain measures in place to try and reduce the risk here, which we're really talking about vicarious trauma. So that was, measures like having counselling available, debriefing sessions, rotating people within the unit, and trying to avoid long hours. And it seems, based on what ultimately fell out in the court findings, that it wasn't just Miss Kozarov, but a number of staff were feeling symptoms associated with stress. Because a group of them, so fast forward about 3 years after Miss Kozarov started, a number of people put together a memo, sent it to management, saying, look, we're experiencing increases in these symptoms, which are really stress symptoms. And they were basically saying, we're disappointed that you've allowed this to get to this point.
So up until that point then, Dom, no one had actually acknowledged it or talked to them about it. They actually had to instigate that this is what we're experiencing right now. Is that right?
Yeah, I mean, it's maybe there were individual comments made, maybe there was some feedback provided at an informal level, but it seemed to me that's a pretty big cry for help. And going to the point of banding together and putting together a memo says to me that they form the view that we need to do something more because we're not being heard.
Yeah.
Now, I don't know if that's right or wrong, but certainly it's a big step to take.
Yeah.
Sure. And clearly they were under strain. So it was so that was followed by a few months later by, in terms of Miss Kozarov, saying to her managers, look, my workload is full. I can't take on any more files.
Yeah.
And then a couple of months later she became ill while she was at work and took a couple of weeks off on sick leave. And then, so that was in June. Yeah. Then in August, but that period of sick leave was quite short. I think there were a couple of periods of sick leave that were interspersed. Yeah. In August, she applied for a promotion in the sexual offences unit where she was working. But it also seemed like she was engaging in behaviour which was out of character. Like she came into work one day and had a dispute with her manager, and the way the decision reads is that for her that was very out of character. Yeah. So what you were seeing was a real shift in her behaviour over what was a quite confined period of time.
Yeah, and it was being noticed within the office and her colleagues as well. They'd noticed that was an out of character, which is one of the main signs, right, when someone is dealing with stress, is that their behaviour changes and they become short, snappy, or sometimes they actually just shrink away and just become completely quiet. So there was an actual change in her behaviours within the workplace as well. Interesting.
Yeah, and in the context of, it sounds like other people were sort of perhaps more alive to it because they were, based on that memo that went to management, they were also suffering to some degree. So there is obviously something going on here that's not specific to one person, but even if you looked at her behaviour on its own, it seems like there was a big shift and quite noticeable. And it just continued to worsen. So that that promotion that she applied for, and she got that promotion. Think I'm correct in saying.
Yeah.
That was in August, the second half of 2011. In February 2012, she sent out an email to her managers and said she was anxious and distressed about having to work in that sexual offences unit and wanted it to be transferred out immediately.
Right.
And the OPP said, well, have you got some medical material which might support that request? And it wasn't long after that that her employment ended. She didn't come back to work. From the point where she was saying, I want to transfer, she didn't go back into work. And then her employment came to an end in April. So that was sort of the end of it in terms of her employment. But obviously, by that point, she was in a fair bit of difficulty because the next step was claiming that she sustained a psychiatric injury and seeking damages.
Yeah, absolutely. Because so just to wrap it up, what I'm hearing is the fact that this is someone that have obviously they've been making noises, not felt as though they've been heard by their employer, which is then resulting in a memo, which then she then looks to take it seriously. Her behaviour also changes, as has been seen by other colleagues. Then she goes for. Was anything done in that time? Do we know whether there was any sort of initiatives or things that were given to her, like counselling or even a rotation of department just to have that break? Was there anything during that time? Do we know?
No, my understanding is not beyond what was already in place, and I think there was a real tension here between the behaviour that was being displayed, but at the same time, it seemed to me, again, just from the judgments, that Miss Kozarov was very committed to her job and her role. And prior to the point where she said, effectively, that's it, I need to get out of working in this environment.
Yeah.
She was very keen, and that's consistent with seeking a promotion.
Yeah.
And clearly it was important to her, that the work was important, and it is important work. There's no question about that. So I think there was a tension between someone wanting to do that, really wanting to do their work, but at the same time it's taking a toll. And I think that I've, in the course of the work that I do, it's not uncommon to hear that from clients and have situations where people are very committed. They want to work. They like working, but it's apparent that there's something going on. Often the issue is we can't tell whether or not it's the work or something else, but there are behavioural changes.
Yeah.
But there's a reticence to do too much about it because they don't want the person to perceive that they're being punished in any way, or that people think that they're no good at their job.
Yeah.
And they want people who are committed to do their job. So I feel like this was that sort of situation where there's a real tension between those different interests.
Yeah, and that's quite common. I mean, I remember when I was back in the building industry, I was stressed. I was highly anxious, highly stressed, but you put the mask on, you carried on, you created a little bit of noise, but you didn't want too much noise because you wanted career progression, and you loved your job. I mean, I absolutely loved it. So you sort of just bit down and you just carried on. Whereas now it's, especially when it comes to a compound effect and vicarious trauma as well, especially when you've got those high risk events and things that you're actually dealing with, you want to do your best, but then there's only so much. We're only humans after all. There's only so much that we can do and take on before we crash and burn.
Yeah.
So what happened with regards to obviously going to the High Court? What was their findings? What conclusion did they come to?
Yeah, it went through a few different layers. So there were two appeals which got it to the High Court. But in a nutshell, the court proceedings started by Miss Kozarov bringing a claim in the Supreme Court in Victoria saying my employer the state of Victoria breached its duty of care to me. It's a claim in negligence. I've sustained a psychiatric injury because of your breach, and I want damages. And at first instance, that was she was successful, and she was awarded $435,000 in damages. And the court said, yes, I'm satisfied that the duty of care was breached because the OPP neglected to take reasonable steps to prevent psychological injuries, and made a finding that, look, the workplace was lacking in preventative measures to safeguard staff well-being and should have had a system in place to monitor staff for red flags that might indicate the need for intervention. And that's a comment that really jumped out at me when I was reading it, because it's a negligence case. It's not a case about whether or not someone's breached WHS legislation. But that issue of looking for red flags and then acting when you see red flags is just as important. So Ms. Kozarov won at first instance. That was appealed by the OPP, went to the Court of Appeal, and they were successful, but because the Court of Appeal felt that it was entirely speculative that Ms. Kozarov would have accepted a rotation out, and they were looking back to mid-2011.
Okay.
So this is more when she was saying, I've got too much work on, I can't take any more, et cetera, et cetera. And they said, look, at that point, we don't think, even if you'd offered her a rotation out of it, she would have accepted it, because she seemed at that point to be very committed, wanted to do the work. And after that, she applied for the promotion or there or thereabouts. So we're not. So we think, the fact that you didn't offer to do that, to our way of thinking, isn't a breach of your duty of care. So the decision was overturned.
Okay.
And that's when Ms. Kozarov sought special leave to the High Court and got special leave.
Yeah.
And they decided in her favour. And it was unanimous. There are different judgments, but it's unanimous. And there were some really key points that you could sort of take away in summary from that judgment. So,
okay.
And it might be helpful just to run through a couple of them.
Yeah, absolutely.
So the first is, and I don't think this is controversial, but there's a duty to take proactive measures to reduce risk of psychiatric injury from the commencement of her employment. I don't think anyone was arguing that otherwise, but they've made a very strong statement about that.
Yeah.
And so, i.e., person comes in, they're exposed from risk from day one. So that's when the obligation kicks in. It's not, and I think perhaps they were saying, look, there's been a lot of focus on things that happened 3 years later. But just to be very clear, this is a duty that exists for the life cycle of the employment. And the next point they drew out was, they said, look, the employer clearly understands that this risk of vicarious trauma was real and significant and almost unavoidable given the nature of the work. And that the longer you worked in that environment, the more detrimental and cumulative the effect on people's mental health. And that was clear from the terms of the policies that they had in place around this sort of stuff. So, you're on notice about it. You knew about it. You did have certain things in place. So that's obviously key. I think in a safety context, if an employer had that level of knowledge, then what they're required to do, or what's reasonably practical, sort of gets elevated.
Yeah.
But in a safety context, it's not just what you know, it's what you ought to know. So here, even if the state of Victoria had said, well, they would never have said this, but how are we to know? You know, well, we're not across the data and the science and the impact of this sort of stuff and, the work that's been done in respect of vicarious trauma. I feel like the court would have said, even if you didn't know, you should have known, given you've got a whole team of people doing this work, you know what's involved in the work. How could you not think that was going to have an impact on people? So that was a very interesting sort of observation.
That's basic, common sense, isn't it, really? If someone's dealing with something that's traumatic, even dealing with a case around trauma happening, it's still traumatic to that person, no matter what role it is, because we're all human. We're not immune to people being hurt and sexual abuses and stuff like that. it's common sense that it's going to affect you, and
Yeah.
you know, so things need to be put in place.
Absolutely. And, you know, in a safety context, what you often find is that when things are being investigated, there's always an element of 20/20 hindsight. And that's natural. That's a human, that's just a function of the way our brains work. So
Yeah.
when I say that, I'm not being in any way critical of regulators and courts. It's just we all do it. But when you take that 20/20 hindsight and you add it on top of things like, matters of common sense, then it means that really what you know or what you ought to be aware of is actually often quite a very broad range of information when it comes to safety risks. So it's always that point of think broadly, think laterally. Don't be too blinkered about when you're going through and identifying risks and working out, what they are and how significant they are. You've got to look at it, from all the different angles, and not get trapped in, your own sort of, limitations of your own knowledge.
Absolutely. And I think even with like sort of she was showing red flags,
Yeah.
And everyone's different, right? Everyone's stress levels, the mask that we wear, I'm okay, I've got this stuff. Everyone's masks are different as to how much they can take on before they start showing signs and stuff. But even when I think it's even when you are dealing with things like this, it's good to have those check-ins and those honest conversations and go looking for it. Because again, people that are passionate and that are driven, that are proud about the work that they do, the last thing that they want to do is put their hand up and say, hey, I'm struggling. I need some help right now. Because that just the amount of people, I can only imagine the amount of people that she feels responsible for, that she's investigating these cases for. So she doesn't want to let them down either. So I think it's even, prominent for employers to actually go looking and sort of creating those psychologically safe environments where people can speak up freely and be heard.
And in this case, she did speak up, but there are lots of instances where people won't go to that point, but they're still showing real red flags, like you say. And the High Court picked up on that too, and they said, look, at the very latest, your obligation to reduce the risk of injury was engaged in August 2011. Yeah. Why? Because she was displaying signs that put you on notice that something was not right, and that triggered your duty to proactively reduce this risk of injury. And really what they're saying is that started at the start of her employment. But at the absolute latest, when you're seeing this behaviour, you can't just ignore that. Something has to be done. And that really was, I think, here, the key, point that led the High Court to flip the decision, because they said, look, you could have offered this person a rotation out of the unit. You could have done that that wouldn't have been difficult. Now, she might not have accepted it. She might have. The point is, though, you didn't even offer it. So, because instead of that, it was more, well, we want to see medical evidence and to substantiate your request and those sorts of things.
Yeah.
Well, and that was later in the piece anyway, but at no time prior to that had anyone said to her, it seems, maybe you need 3 months to just go and work in another unit, and have a break from it. And that really, that's what did them in this instance. So it's, and again, like if you take that up, you could pick that up and apply that in a WHS compliance context.
Yeah, absolutely.
Which is the need to be proactive, the need to take steps, and the fact that someone might not like it, or the fact that someone might push back against it, is not of itself ideal, but that is in no way a reason not to do it. Because at the end of the day, you're dealing with situations where people think or might think they're doing okay. They're not seeing the bigger picture. They're not necessarily cognizant of the behaviour that they're displaying and the symptoms. Other people are seeing it, and it does seem paternalistic I think, to some people, to say to employers, you have to step in and effectively play mum and dad.
Yeah.
Because you have to sort of offer it to them and maybe tell them, direct them out, or etc., which, creates its own issues. But what the High Court's saying is you don't have a choice. Where you're on notice of issues like this, you have to act. And that's really my key takeaway from that case. It's a negligence case, but in the world in which we work, which is, looking at WHS Act compliance, those observations, I think, are very powerful.
Yeah, absolutely. Because it is a negligence case, but a lot of what they're saying is being pulled from the health and safety legislation, about now being proactive about going out looking for risks and hazards and stuff, and doing stuff, not just waiting for someone to come up and say, hey, I've got a problem. So what do you think the biggest thing that employers could do right now to learn from this case? What things do you think that they should be looking at right now that they can actually action?
I think that one of the biggest takeaways from this, apart from the point that I was just making about you can't just sit on your hands, you need to act, and if you're adopting a robust risk-based approach, you will be doing that anyway, because the idea of that is, of course, you're trying to get ahead of the game. You're trying to do this proactively. You're trying to stop these risks manifesting. But I think that observation that was in the original decision about not being a system in place to monitor staff for red flags, that's crucial. I think in the psychosocial space, you need to have that. And that is something that a lot of us, and myself included, it's not something that we are taught about when we're studying. It's not something that is intuitive necessarily. It's something that is awkward. And it because people worry about having conversations and sort of calling out certain behaviour, even if done in a very delicate way, because it feels intrusive. But really, that discomfort needs to be dealt with, and worked through, but effectively put to the side. And you, no matter what organisation you're in, you need to make sure you've got measures in place to make sure that people, and generally it's the people who are managing and supervising people, because they see them all the time. If anyone's going to pick up a change in behaviour, it's more likely to be them. They're those changes in behaviour are the red flags. They're the ones that need to understand, what is a red flag?
Yes.
Is it or isn't it? If I'm not sure, who do I ask? And if I think there is, how do I go about responding to that? And
absolutely.
Having the resources and the training to better arm people to do that in a way that's sensitive. But the time for not asking questions has passed us by. If there ever was such a time,
Yeah, absolutely. And I think a lot of, when I talk to my clients and stuff, and when we're talking about having difficult conversations or talking to someone that is struggling, because no one wants to have those conversations because it is uncomfortable and you don't know what's going to come from it either. But it's sort of like, just because you're their line manager doesn't mean that you're the one that has to have the conversation. If you know that there is someone else that they're closer to or more open to or connect more with, you use that person to start the conversation. Because at the end of the day, the way that I look at it, and especially putting it on the building site, going back from my history, is that I always look at the angriest man on site or the angriest woman on site, and I can guarantee you that they do not want to feel like that. They didn't wake up and just decide that that's where they wanted to be and that's what they wanted to do, and they wanted everyone not to come anywhere near them and no one to talk to them and to have a really unhappy and angry existence. They don't want to be like that. But a lot of the time people are stuck. So and there are so many ways of being able to unpack the conversation depending on the type of person, but the number one thing is, you don't have to be, if there is someone else within the business that that person that's struggling or their behavior has changed, that they get on with a lot better, use that person. Don't not say anything always ask.
And there's so much upside. Like, I've seen it firsthand. I've heard it from clients that sometimes just asking the question is enough of a circuit breaker to cause that person to actually have a moment of realization and think, right, I don't think I was aware of that, or I was, but I didn't realize that I was effectively just disclosing it, or telegraphing it to people. But clearly I am, and at least someone cares enough to have asked. And I've seen, and heard, and it goes from what could have been a very troubling trajectory potentially if everyone had just let it be, to a situation where quite quickly it sort of doesn't turn around, but it starts picking up, and people are better for it. So I try and use that example too when I get the sense that people are reticent to say, this could be the biggest favor you've ever done for somebody.
Absolutely.
So just try and have that in the front of your mind, because it is all coming from a good place. So, if that's your motivation, you shouldn't feel bad about it, but you need to know how to do it. Or if you don't know, like to your point, there are people who can.
Yeah.
So
absolutely.
it doesn't have to be you personally, but just make it happen.
Yeah, absolutely. Well, thank you so much for unpacking that with me today, Dom. We will be putting the link of the case in the description notes. So if you want to have a look and read through the notes from the case, you're more than welcome to. But thank you for listening. Until the next time, take care. Bye.